Hi, I'm Anya Donovan, the Executive Director of the Ethics Institute. It's really my pleasure that you're here, and so many of you are here. It's always terrific. I'm sure you're aware of the fact here at Dartmouth, we put in huge effort bringing people to campus, and there are times you'll have the most fantastic person in the world, and it's rather a small group. I knew when, I think it was a year ago, I came up with the idea of inviting Neal, and I thought, this is going to be a home run. So much of a home run that about, I think it was 3 weeks ago, Neal emailed me and said, Anya, I am really sorry, but I can't do it. Oh, panic. We'd already advertised. We had students really excited about it. And he said, I have this little thing in Hawaii coming up that may interfere. So through the generosity of donors to the Ethics Institute, we are really lucky that we're able to get excellent transportation to get him here, but he is going out as quickly as he finishes here because he's a very busy fellow. So I wanted to tell you that the Aaron Lectureship, a little bit about the Aaron Lectureship. A few years ago, I met with Roger Aaron's widow, Ginny, Bill, and Roger's sons, Peter and Todd, and we came to the conclusion that the Aaron Lectureship should simply be focused on the idea of bringing people to campus who represent the best in ethical practices and scholarship, and that was the most fitting for the format that we wanted to pursue. For those of you who did not know Roger, he was a longtime partner at the law firm Skadden, Arps, Slate, Mayer, and Flom, and helped to orchestrate some of the biggest mergers of the past several decades. But perhaps most important of all, for those who were his family and friends, he was a man of integrity. And so putting a fund into the Ethics Institute to honor his legacy as a Dartmouth grad and a lawyer who did such incredible work seemed absolutely the right thing to do. And I do think that Roger would be very happy with my selection of Neal Katyal as a third Aaron Fellow. So let me just tell you briefly, you're here, you probably know who Neal Katyal is, but he's a partner at Hogan Lovells and a professor at Georgetown University, which he was just extolling the virtues of with a large group of students at the Ethics Institute who are, I'd say about half, at least half of them were either applying to law school or will be applying to law school. And had a wonderful opportunity to meet with him. He specializes, as you probably well know, on constitutional and criminal law as well as intellectual property. Neal is a Dartmouth grad, proud Dartmouth grad, received his law degree from Yale, and he served as the Acting Solicitor General. He's argued 25 cases before the Supreme Court, and really some of the most important cases of our times. We are extremely fortunate to have Neal Katyal here today, and please join me in welcoming him.
Thank you. It's a real honor to be here. I see some people out there, and you're welcome to come. There's some stairs over here if you want to come in, and some on and some on this side. Please don't feel like you have to stand out there.
And there's overflow, if you don't mind.
There's overflow upstairs as well, but you're welcome to come in here. So it's an honor to be back here at the college that I love so much. This college has basically made me who I am. I'm particularly pleased to see two of my professors and mentors here, Roger Masters, who I wrote my thesis with, and Doug Haynes, who taught me basically how to write. And I wouldn't be here if it weren't for these two gentlemen, and I can't thank you enough. Ray Hall is another person who isn't here, I think, but was crucial to me. And then actually my debate coach, Ken Strange, who basically taught me how to argue. And he's he's sadly in a hospital right now, recovering from heart surgery, but I think he's going to be okay. It's a pleasure to be here. It's an honor also to be here as the Roger Aaron lecturer. I never had the pleasure of knowing Roger, but I have gotten to know Ginny a little bit, his wife. Roger actually has the exact same pedigree as I do, Dartmouth College, Yale Law School. And it is a tragic thing that he was taken from us way too early. And I will try today to honor his legacy in the best way that I am able to. I also recognize that it is, late afternoon, and It's a gray day outside, and my students tell me that I put people to sleep sometimes. I have a soporific effect on them. I think Professor Haynes knows this story. I told it a few years ago, but at Georgetown, we've moved to blind grading, so you don't actually put your name on the exam. And the reason for that is that you have students all semester who would kiss up to you, and then you'd read that exam and you say, oh, Jane Smith, she's so lovely, and it's hard to discount that in the grading. And so that's why we go to these numbers. Your exam is like 42849, and I just grade it knowing that. But the Georgetown students are clever, and so they've come up with ways around this. So at the bottom of exam 4289, it'll say something like, Professor, thank you for the greatest class ever. Or, you're such a beautiful ties, or not today, obviously, but, like the one that gets me is, your children are so beautiful, So, but, you can generally discount that. But a few years ago, before I was here lecturing the last time, I think in 2011, I had a student who said, Professor, should I have 1 hour left to live? I should like to live it in your class. And I'm thinking, wow, does Georgetown have A pluses? And, it's a law student exam, and law students, they love their footnotes. So I turn the page over. There's a footnote saying turn the page over, so turn the page over. That is because, Professor, you make 1 hour seem like an eternity. So I will, I won't keep you that long, and I will take some questions. We'll try and keep this a little bit lively. And it's an interesting thing. Last year, when Professor Donovan asked me to come and to speak, the title that I said I would give her was "The Rule of Law in the Executive Branch," is what I think you see on the poster. And that comes out of my academic work. My academic work is about the idea that we should be creating, and we have created since the New Deal, checks and balances within the executive branch. To take James Madison's idea about separation of powers, the three branches of government, and to lace it into the executive branch itself. And that's a way of checking and balancing an executive that is trying to be aggressive. So that was my academic work, and I thought I'd be talking about it. And then, with each passing day or week after November, that's been a little bit harder to think about. Particularly when the acting Attorney General is fired, Sally Yates, the head of the Southern District of New York, the U.S. Attorney, Preet Bharara is fired. It was getting harder, but I was still, up until yesterday, that was my title, and I was sticking with it. It's not my title anymore. Yesterday's events do lead me to think that, it's hard to think about checks and balances in the executive branch anymore. And so I was searching for a new title yesterday, and I was reading about the Ethics Institute here, and one of the things I read is that one of the advisors to the Ethics Institute is a man named David Souter, Justice Souter. And Justice Souter embodies, I think, the best of this country, regardless of your politics. Just someone who is trying to get it right and who did work his tail off to try and be a reasonable, sober voice. And so I was thinking that should be the title. So the title is now, quote, "Our Last Best Hope for Constitutional Order, the Courts." And it comes from Article 3 of our Constitution, which of course guarantees life tenure to our judges for precisely occasions like this. And so I've been thinking in the context of this lecture, for a long time about what to talk about, and I have wanted to talk to you about, a case example, the Muslim ban case that I'll be arguing on Monday before the Court of Appeals. It'll be in Seattle. I don't argue too many cases in the Court of Appeals. I generally argue cases in the Supreme Court, and I'm at 34 now. So, and it's no worries. But the numbers have been I just had one last weekend, one the week before. So it's been a pretty intense time. I think that I'm going to talk about why I think the courts are a good place for this kind of check and balance. tell you a story about why I'm particularly optimistic about the courts, and then tell you another story why I'm a little bit cautionary about the courts as well, and then take your questions. So what is this Muslim ban case? Well, on December 7th, 2015, President Trump issued a statement calling for a ban on Muslim entry into the United States. He read it aloud. He likes to speak in the third person. Quote, Donald J. Trump is calling for a total and complete shutdown of Muslims entering the United States until our country's representatives can figure out what the hell is going on. The audience erupted in applause. Democrats and Republicans alike, however, weren't so optimistic about this, including a guy named Mike Pence, who rushed to condemn the proposal as unconstitutional and un-American. But Trump, as candidate, refused to back down. In an interview a few months later, he said, quote, I think Islam hates us. We can't allow people coming into this country who have this hatred of the United States. And, that first statement that I just read to you, calling for the complete and total shutdown, has been on his website until about 2:15 p.m. on Monday, this Monday, 2 days ago. We had been pointing out, as I've been litigating this case in the courts, that it had been up on his website, and then before the Court of Appeals argument in Virginia on Monday, which started at 2:30, it somehow miraculously disappeared. What's the litigation about? It's about his formal executive order, which was issued he issued one first on January 27th, and it's called, and he read this title out in front of the cameras. He read it. It's called, quote, Protecting the Nation from Forced Terrorist Entry into the United States. And as he signed it, he looked up at the cameras after reading the title, and he said, we all know what that means. And we do. It's a thinly veiled attempt to try and make good on his campaign promise to ban Muslims from the United States. That first order blocked folks from 7 countries from coming here that are predominantly Muslim, and definitely blocked all Syrian refugees. And it also, but it did have an exception for certain refugees. Indeed, that night, on January 27th, the night of the executive order, he went on the Christian Broadcast Network television show and said that it means that Syrian refugees who are Christian would be allowed to enter the United States because they have whereas Muslim ones wouldn't. And obviously, we saw the chaos that erupted in the airports and so on, the protests and the like. President Trump said, see you in court, ! And certainly the challengers did see him in court. He lost in court, over and over again. And he then said he was going to take it to the Supreme Court, but then he wound up not doing that. He withdrew the executive order and said he would write another one. And he's writing another one, and he has his main advisor, Miller, say it's the same policy outcome. We've just made a few technical changes. And so that's when we, got involved. I started representing the state of Hawaii, challenging the second one. And we brought it to court. This order was supposed to go into effect on March 15th, and we brought a lawsuit and argued the case on March 15th, and then ultimately the judge in Hawaii enjoined the case, saying it was unconstitutional. That led Donald Trump to say the following, that just a few hours later, at a kind of campaign rally, quote, moments ago, I learned that a district judge in Hawaii, part of the much overturned Ninth Circuit Court of Appeals, just blocked our executive order. This is a watered down version of the first one. And let me tell you something, I think we ought to go back to the first one and go all the way, which is what I wanted to do in the first one. The best way to keep out foreign terrorists, or as some people would say, radical Islamic terrorists, from attacking our country is to stop them from entering our country in the first place. Now, his lawyers had spent a whole bunch of time saying the second order is not like the first one. Of course, this was a little bit problematic for them. So I basically think of Donald Trump, who's the defendant in my case, as my co-counsel. So I just basically think, just give the guy a microphone and we're going to be okay. So what's the case about? Well, it's about a kind of it's about what America's about. If you think about the founding, it's the idea that people came here because they were fleeing religious persecution. The Pilgrims left England because of the Act of Uniformity, making their religion illegal. The colonies of Pennsylvania and Rhode Island were established for people to be free of religion. But it wasn't always so. I mean, you definitely had some bad things happening at the colonial time. I mean, Virginia, for example, they wanted to establish an Anglican church. And so what did they do? They barred immigration of Catholics in order to basically make the populace Anglican. And so you have this kind of long tradition of immigration being used in the colonial era in order to be a way to enact a certain religion, a favored religion. And certainly we've had, ebbs and starts of more religious freedom and less. I mean, obviously there's horrific things that happen to Catholics, that happen to Mormons, as well. And oftentimes these religious policies share kind of the same basic animus at its root. We can't trust you, this other type people. And because you can't trust them, we're just going to bar you. We're going to, not give you certain jobs, and so on. And so that's really what the case is about, which is, can the president basically say he wants to bar people of a certain religion from coming in to the country? And I am very optimistic about this case. I mean, there are 9 people on the Supreme Court. 5 are certainly appointed by Republicans and 4 by Democrats. But this is something I think everyone can agree upon, that what is the essence, what is the root of our society? It is a pluralistic one in which we don't care, as Jefferson once said, we don't really care who you pray to. That doesn't affect me. As long as you, work hard and act peacefully, no problem. And if someone doesn't act peacefully, then obviously you throw them in jail, but you don't condemn their religion. So why am I optimistic about this? And I'm going to move away from this case and talk more generally about the role of the Supreme Court in checking presidents, going back to my new title. So, I was... a law professor so I'm a law professor, but I was just a law professor. I wasn't litigating cases for a long time. And after the horrific attacks of 2001 on September 11th, I remember I was teaching in New Haven at the time, and it was in November, and I was watching the TV, and at the bottom of the TV screen, the news had gone to that crawl thing after the attacks. So the bottom of the screen said, President issues military trial order for suspected terrorists at Guantanamo Bay. And I thought to myself, that's really interesting. When I was National Security Advisor at the Justice Department in the Clinton administration, I had really tried to go after bin Laden. We had the embassy bombings at the time, and so we'd done all sorts of things, some of which have become public, covert operations. So there was military side. There was also a big legal side as well. And so we were looking at all sorts of things, and we, in fact, looked at military trials. But military tribunals needed a law of Congress, we thought. And so I was like, I wonder how the president could do that, President Bush. And so I went and I used my dial-up modem at the time and typed in, if Google existed, I didn't know how to use it, so I typed in like whitehouse.gov onto the search bar. And I came onto the White House website, and it was the president's order for these military trials. And honestly, the first thing I thought was it was a joke. I thought I was on like a spoof website, like, there's fake White House websites, because the president was saying, I'm the president, I can set up these military trials entirely by myself with the stroke of my pen. I can pick who's going to come before them, the defendants. I can pick the prosecutors. I can write all of the rules for the trial. I can define all of the rights that the criminal defendants had, which he said are zero constitutional rights. I can pick the punishments, which he said include the death penalty. I can define what the offenses are, the elements of each offense. I can handpick the judges, handpick the appeals judges, and the very last lines of his order said, the federal courts have no business reviewing what I'm doing at Guantanamo Bay. So he was putting people to death in these tribunals with no oversight, just a complete system that he was running. And I walked into my constitutional law class the next day, and my students always tease me because they think that I'm such a deferentialist to the executive. They're like, you don't think anything the president does is ever unconstitutional. So I came in and I said, here's something that is blatantly unconstitutional. So there was someone in the class who had worked for Senator Leahy, and so Senator Leahy found out about my views, and he had a hearing, and I testified at the hearing and said this is unconstitutional. And then Larry Tribe of Harvard, very famous constitutional law professor, testified a couple weeks later and said the same thing. And, we did what academics do. We wrote a law review article saying it was unconstitutional. We thought that would do something. It didn't do anything. The president launched his Guantanamo trials. And then I faced my first real inflection point in my life. This is a, institute about ethics. And, this is an important question for me. My dream job was to be national security advisor at the White House. That's what I really wanted to be. I didn't think of myself as a litigator. I hadn't really argued much in court. I'd argued one case, some criminal case when I was at the Justice Department, but not a tiny little thing. But I never thought of myself as a courtroom lawyer. And I really loved the idea of protecting our nation's security. That's like, the nation gave me so much. And so then I thought, I'm going to challenge the president. I'm going to bring a lawsuit against the president. It's a tough thing to do. But I really believed that someone had to stand up and say this was wrong. Back in the early days, 2000, in 2002, 2003. And so I started working with the Navy Judge Advocate General attorneys who were assigned to the defense to create a test case. And, in strategic litigation, one of the most important things to do is pick your plaintiff. Who's the person who's going to tell your story? Now, this is not like your usual case in which you're trying to pick between one lovely plaintiff and another. These are people at Guantanamo, okay? So, everyone's going to be alleged to do something bad, but within that, there's still parameters. And so I said to the JAG attorneys, I said, listen, I don't want someone who's got blood on their hands. So Charlie Swift, Lieutenant Commander Charlie Swift calls me up and he says, I've got the solution. I've got it. I've got someone. You want the good news or the bad news? I said, give me the good news. Okay, no blood on their hands. Great. What's the bad news? Well, he's the driver to a bad guy. I said, who's the bad guy? Osama bin Laden. And that's when the inflection point really does happen. Then you think, okay, you're going to represent bin Laden's driver. You want to be national security advisor? That's not going to happen. But because I had been a robust voice for national security in the last administration, particularly on this set of issues, I thought it was particularly important that there weren't that many people, yes, you had, civil libertarian groups who cared about Gitmo, but to win in a Supreme Court that was 7 Republican appointees and 2 Democratic appointees at the time, I thought required someone who was more centrist. And so I said, listen, I think we should do that case. I think we can win that case. And so I started representing Osama bin Laden's driver as a law professor, and arguing that what the president was doing was unconstitutional, and going to the federal court in Seattle where we filed the case to argue this. And I argued in the federal court, and I'd been trying to see my client, Salam Hamdan, for 5 months before that district court, that trial court argument. And the Justice Department wouldn't let me go. And they said I didn't have security clearances to go. And I said, listen, look me up. I have more security clearances you ever heard of. And they looked me up, and I'm like, yeah, they do. And then they said, well, okay, you've got the clearances, but you don't have need to know. Because in the security clearance world, you got 2 things. You've got requisite level of clearance, so you have that check, but then you also have to have a need to know. And they said, listen, you're making legal arguments to the court. You don't need to meet your client to make them. They're abstract constitutional arguments. And I am so deferential to the government ordinarily. I thought, oh, that seems right to me. I have been making these arguments. And I hung up the phone. I'm like, wait a minute. No, he's my client. I can meet my client. I have a need to meet my client. They're his arguments. I should get to meet him. So then I thought, okay, I call him back. I say, can I have that in writing? And then I got to go to Gitmo because they knew I was going to give it to the New York Times. And then, so I get to go to Gitmo, but they made it really hard. They made it, it's a 30-hour, they made it a 30-hour trip for me. I had to drive to Norfolk, get on the naval base, spend 4 hours waiting for the plane to take off, and then fly to Jacksonville, refuel for 8 hours, fly around the island of Cuba, not over it because Fidel would shoot it down, and all sorts of stuff. It's 30 hours door to door. But then I do ultimately get there and I meet my client, Mr. Hamdan. And he says to me, everyone else out of the room, I had a translator, a Charlie Swift, the military attorney, I had a couple of students, kicks them all out. He says, I want to talk to you. Oh man, he's going to yell at me. And he had been in solitary confinement for 10 months where he had not seen another human face at all. Our CIA manuals say you do that to someone for 3 days, it causes a risk of permanent psychosis. But this had been 10 months of his life. So I think, he should be able to yell at me, And he says to me after everyone leaves, he says, I just have one question for you. Why are you doing this? Why are you representing me? And I said to him that I didn't say anything for a while. I was like, I've been arguing his case and all the line-by-line argument, but I've never sat back and thought about that question. And so I'm silent for a long time. And then I'm thinking to myself, I remember this all in my head, I'm thinking, God, this is why you should stick being a law professor, because, client asks you a simple question and you can't answer it. And then so like 45 seconds go by, and then I thought to myself, well, maybe it's okay, because when, Justice Ginsburg, if you ask her a question, she'll often pause for a long time before answering it, so maybe I'm okay. And then another 5 seconds go by, and I think, well, that doesn't matter. He doesn't know who the heck Justice Ginsburg is. But then I tell him this. I say to him, look, the reason I'm here is simple, that my parents came to this country from India, and they didn't come to America because of the quality of its sports teams or the quality of its soil. They came here for one simple reason, which is they could land on its shores and be treated fairly, and indeed, their children were treated fairly. And I said, listen, the experience in my life, Mr. Hamdan, has been that my country has given me everything, the best universities, the best government jobs, that's my parents' vision of America, and it had always been what I'd seen as my vision of America as well, until this order. Because this order by President Bush said, if you were one of the 5 billion people around the world, or the 12 million green card holders in America, like my parents were, and you committed a crime, you'd get sent to Guantanamo for it. And if you did the exact same crime, but you were an American citizen, you got the Cadillac version of justice, the U.S. criminal justice system. And I said, that's literally never happened in American history. From founding on, we've never done something like that. We always have one system, not two, for the same offense. And so he thought that was satisfactory. We brought the case, we continued bringing the case. We lost it in the Court of Appeals. Ultimately, it became my first U.S. Supreme Court argument. It was my opponent, the Solicitor General's 35th. It was very nerve-wracking for me, but ultimately, we won 5-3 at the Supreme Court of the United States in June 2006. And when we won, we didn't just shut down the Guantanamo military trials. We also established the principle that the Geneva Conventions apply to the war on terror globally, which meant that ghost prisons were shut down, which ended waterboarding, and ended a whole bunch of enhanced interrogation practices. So I remember in the courtroom that day listening to the opinion come down. It's a 174-page opinion. And you could hear a pin drop as it was being read. And you don't read, Justice Stevens, who wrote it, you don't read the whole thing. He's just summarizing it for about a half hour. And then the dissents come for another 15 minutes, those who disagree. And so Justice Scalia began by saying, blood will be on your hands, looking at me, for bringing this case. Justice Thomas said, I've never felt so passionately before to read a dissent in open court, but I have to this time. He had actually read a dissent before, he'd forgotten. But it's a really moving moment in the court. And I walked out of the court, and there's 500 television cameras on the courthouse steps, and the president has just given a press conference about this while we're still in there. And everyone's saying, what does it mean? What does it mean? And I said, listen, I hadn't read the opinion because it just come down. It was very long, as I was saying. But I said, here's what it means. It means that in America, you can have the lowest of the low, the guy's accused of being the worst of the worst, driver to the worst guy on the planet. And you can bring a case not just against anyone, but the highest person in the land, the President of the United States, the most powerful man in the world. And you can bring your case not in some little court, traffic court, but in the highest court of the land, the Supreme Court of the United States, and you can win. That is something profound about America. In many other countries, Mr. Hamdan would have been shot for bringing his case. And more to the point to me, his lawyer would have been shot. But that is what makes America special. And that's what got me thinking about are the magnificence of our system, and that to me is the true message about what America is. I am a unabashed American exceptionalist because I think our system is so good because we understand even our leaders can make mistakes and that we have a system in place to correct them. And so that's why I'm optimistic about using the courts. That's why the title is the title that it is. But I told you I'd also have a cautionary tale for you, and I do. And sometimes those checks balances don't work and the courts don't work. And the best example of this, and is one known to, I think, everyone in this room in some ways, but I'm going to tell some other parts of the story which aren't as well known, are around the Japanese internment in World War II. So you have, and this is my last story, and then I'll stop and take your questions. But in the Japanese internment, here's the way it starts: is you've got the attacks on December 7th, and then in February, FDR issues an executive order that leads his general, John DeWitt, to essentially say the Pacific, the West Coast is an area of danger, and special restrictions have to be imposed, particularly on those of Japanese ancestry. And those restrictions start with curfews. You can only be out until, I think, 9 o'clock if you're a Japanese American. And that includes U.S. citizens who are Japanese Americans. And then later become the forced internment and relocation of 120,000 Japanese Americans away from their homes. Now, there were a few people, brave people, who thought to challenge this scheme. And the story I want to tell you about is not about Fred Korematsu, who's, I think, someone you've probably heard that name, but Gordon Hirabayashi, who actually brings the case right before that. Now, Gordon is 18 years old. He is a student at the University of Washington in Seattle. And he's got a religion, it's a Japanese version of Quakerism. By the way, Gordon was born in the United States. His parents were born in Japan, but he's born in the United States. He's never set foot in Japan. But the restrictions apply to him. So he goes and he violates the curfew on purpose, and then he goes and turns himself into the FBI and says, I violated the curfew, please arrest me. And they're like, hey, it's your first offense, don't worry about it. Gordon goes through this whole thing with the FBI saying, listen, I'm a Quaker. My duty is to resist this unjust law. You have to arrest me. That's part of my religious duty. So they arrest him. And then they put him in trial at the federal court house in Seattle. And at that trial, he defends himself saying, look, I did it. It's just that this law is unconstitutional and unjust. The idea that Japanese Americans would be restricted in this way. The judge says, well, you're admitting it, so you're guilty. And he comes back for sentencing. So Gordon comes back for sentencing. And at the sentencing, the judge says, listen, I got, again, good news and bad news. Okay, the good news is, Mr. Hirabayashi, we do not have any resources to really send you away to the prison camp that you'd ordinarily be sentenced to. And so you're basically, I don't have a way to sentence you. So what's the bad news? The bad news is, well, you're free to go. And you said to me before that you're a Quaker and you have a duty to do this, but I don't have any resources to get you to the prison camp. The only prison camp that's open is one in Tucson, Arizona. It's 1,000 miles away, a little bit more than 1,000 miles away from Seattle. I can't get you there. Gordon says, don't worry about it. I'll get there. Gordon, 18-year-old student, hitchhikes to Tucson to serve his sentence. And he gets to the prison camp in Tucson, and he says, gets there at night and says, I'd like to see the warden. I'm here to report to serve my sentence, 60-day prison camp. And the warden says, I don't have any papers about you. Don't worry about this. Go back, okay? Gordon goes through the whole thing again. I'm a Quaker. I got to serve my sentence, blah, 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 blah. It's my religious duty and so on. The warden says, okay, come back tomorrow. We'll figure it out. He comes back tomorrow, and they figure out who he is, and he starts serving his sentence. But that's the kind of man he was, Gordon. He was someone who didn't take up revolution against the government. He fought within the system. He said, this is unjust. I'm going to serve my sentence, but heck yeah, I'm going to bring a case to the Supreme Court of the United States saying that what's going on is unconstitutional. Then, like now, cases in the Supreme Court of the United States are handled by the Solicitor General. The Solicitor General at the time was Charles Fahey. who later went on to serve with distinction for 30 years as a DC Circuit, our nation's second highest court judge. But at this time, he's the Solicitor General. And then like now, you have a bunch of line attorneys in the office who are responsible for writing the drafts of the briefs. So this brief, in the Hirabayashi case, is assigned to an individual named Edward Ennis. And Edward Ennis starts writing the brief, but he learns that there's a problem because General DeWitt has written this report justifying the Japanese internment, saying basically, we don't know who's loyal and disloyal, and so we need to intern them all. Here's the problem. The Navy, the Office of Naval Intelligence, had concluded all of that was poppycock, was all made up. And there was a report by Ringel saying that there was by Kenneth Ringel, saying that only a tiny percentage at most of Japanese Americans were disloyal, and those that were generally already known to the FBI. The report, the Ringel Report, concludes, quote, the entire Japanese problem has been magnified out of its true proportions, largely because of the physical characteristics of the people. And J. Edgar Hoover, who is running the FBI, who's no fan of civil liberties, agrees with the Ringel Report, okay? So Ennis, as the line attorney to the Solicitor General, does what any responsible line attorney would do. He writes a letter to the Solicitor General saying, we can't defend this. And he says, quote, in light of the Ringel Report, we must consider most carefully what our obligation to the court is. I think we should consider whether we do not have a duty to advise the court of the existence of the Ringel Report. It occurs to me that any other course of conduct might approximate the suppression of evidence. The suppression of evidence. This is all in memos. What does Fahey do? He does nothing. In fact, well, he does one thing. He orders his deputy, who's above Ennis, to take the drafting away from him and to double down with 15 pages of facts saying that Japanese can't be trusted. And the facts are basically that there are schools that Japanese parents have been setting up to teach their children the Japanese language, and those are fronts for indoctrination. And so those are some of the facts. And then the other facts are that the Japanese Americans are signaling to submarines off the coast of California with mirrors and shortwave troop movements and information about our critical infrastructure. They're using radio waves and other sorts of signaling to do this. Problem with that is the FCC, which had the lead on that, concluded that that was absolutely bunk, that there was zero evidence for that, so they had to suppress that as well. And, ultimately what happens in the case is that Ennis starts working with another line attorney, a guy named John Burling, who was legendary DC family, Covington and Burling, almost as famous as Skadden, a law firm. Burling and Ennis get together and they basically say, we can't sign this brief, we can't file this brief. It is lying to the Supreme Court. And they say that to the Solicitor General in writing. Solicitor General says, I don't care, I'm going to do what I want. So those two actually did something remarkable. They went down at the Justice Department. The Solicitor General was the number 3 person in the department. They went down to actually the number 7 person, the head of the criminal division, and explained what was going on, not because they're trying to put anyone in jail, but because the person who was running the criminal division was a guy named Bert Wexler, a legendary figure, Columbia law professor, who kind of had a really strong sense of ethics. And Wexler looks at it and said, absolutely, we can't file this. And so what they ultimately agree with Fahey, Wexler works it out to basically say, well, let's kind of write a footnote that disavows what the final report, what these reports say from General DeWitt, trying to justify the internment. And so the footnote reads as follows. This is in the brief to the U.S. Supreme Court. Quote, the final report of General DeWitt is relied on in this brief for statistics and other details concerning the actual evacuation and the events that took place thereto. We specifically recited in this fact the briefs relating to the justification for the evacuation, of which we ask the court to take judicial notice, and we rely upon the final report only to the extent it relates to such facts. So basically, what Fahey said is, I'm willing to put a footnote in that disavows this report of General DeWitt. And then they write that footnote. And I just read it to you, and I've read this now probably 400 times. I still don't know what it really means. And this is true in government all the time. When I was Solicitor General, basically, you'd have different agencies who had different views on something, and really clashing views, like EPA and Commerce, you could imagine, or State and Defense. And so they say, well, let's paper it over. Let's write a footnote that nobody can really figure out, so try and compromise and kick the can down the road. And that works in a lot of government documents. It does not work in the Supreme Court of the United States because you have a pesky thing called an oral argument after you file the brief. And if you put a footnote like that in, you're going to get asked about it because, it's obvious that you're just trying to hide something. And, that's exactly what happened. Fahey goes up to the court to argue the case. Justice Jackson, who had been Solicitor General, asks him, what is this footnote? What are you talking about? And Burling and Ennis had signed the brief thinking that Fahey had said, I'm going to disavow, and so on. And this is what Fahey says in response to the question by Justice Jackson. Quote, there is nothing in the brief of the government which is in any different in this respect from the position it has always maintained since Hirabayashi's case, that not only the military judgment of the general, but the judgment of the government of the United States has always been in justification of the measures taken, and no person in any responsible position has ever taken a contrary position, and the government does not do so now. Nothing in its brief can be validly used to the contrary. That's the highest officer of the United States government speaking to our highest court in the land, saying there's no evidence that contradicts General DeWitt's report. This is after the FCC, after the Ringel Report, after Hoover, after Ennis, after Burling, after all of that. That's what he says. Any surprise that, I was always taught, when I was taught here at constitutional law, I was taught the court really got it wrong in these cases, these Japanese internment cases. And, maybe, but they're 9 generalist judges, and they're only as good as the their judgment has to be informed by what the intelligence is that the government is presenting to them. And they were told this is what was necessary. It's not surprising to me that they came out the way they did, unanimously in Hirabayashi for the government and later in Korematsu 6-3, because all this evidence was suppressed. And nearly 70 years later, when I got to hold that office, I set the record straight. I acknowledged the existence of the report. I acknowledged that it would have made a difference. And it's a cautionary tale about when courts can get stuff right and wrong. And if you have a government that is bent on pushing national security rationales based on fake evidence, that's the result. You get Korematsu, you get Hirabayashi. And so that just leads me to the end of this, and we've come full circle, because literally tomorrow, May 11th, it'll be 13 years ago that on that day, May 11th, that I walked into federal court in Seattle and to file the Hamdan case and to do my first argument in that case. It was my second argument ever in my life, including I'd never done traffic court, but it was that was it. Second argument in Seattle, and it was filed in that federal courthouse. And I went back and I looked at the judge's order from that day, because it's very interesting. He has a footnote at the end of the order in the Hamdan case from 13 years ago. Quote, "It is very appropriate that a case of this significance bridges the last days of the Nakamura Courthouse in Seattle and the opening of our new federal courthouse. The present Nakamura Courthouse has been the venue for many important cases in its 65 years of use, including the trial of Gordon Hirabayashi in October 1942 and Korematsu versus United States, both of which occurred in the aftermath of Pearl Harbor, and they both serve as constant reminders of our country and our courts must always remain true to the core principles embodied in the United States Constitution, even in the aftermath of devastating attacks on our people, and even in times of war. The hearing leading to the decision that Mr. Hirabayashi's conviction for failing to report for internment was an error also occurred in this Nakamura courthouse 44 years later. On Monday, in 5 days, I will go back to the Nakamura courthouse for the first time since that time 13 years ago to argue to strike down President Trump's Muslim ban. Questions? Yeah, sure.
Do you accept a comment?
Well, if it's a speech, I think, probably people are tired. So if it's a short comment, great.
My name is Pete Burling, Jack Burling's son.
I think you've got the floor.
I just want to say, when you said you set the record straight, perhaps you didn't carry the full impact. There are not many times when the Solicitor General of the United States files a document called a confession of error. And when I read that, it brought a lot back to me. And I'd just like to say it's an honor, sir.
Okay, top that, someone. Yes, sir.
Can you tell me how we have gotten ourselves into this flap of not approving the appointments of the president to the point where the head of the Senate, leader of the Senate, can delay indefinitely? Is that a flaw in our Constitution, or is that a flaw in the rules? Or is it one of these things that just by omission, because no one ever thought it would happen, that we'll live with?
It's a great question, and I think that part of what may be motivating your question, tell me if I'm right, is Merrick Garland was nominated to the Supreme Court and had to wait hundreds of days and never had a hearing. Is that what you're getting at?
That plus the 100 and some odd federal judges that were never approved.
Yeah, so it is a real issue. I think our constitutional system has operated not by dint of legalizing everything and requiring it, just kind of norms of constitutional etiquette. Like, you nominate someone to the Supreme Court, they should probably get a hearing. And that's been the tradition. And so we have seen people willing to shatter those traditions. And it'd be a shame if we have to kind of micromanage everything and make laws or constitutions that said, oh, you've got to give everyone an up and down vote, because in general, you want to presume good faith on behalf of our legislators, and you shouldn't have to, tell them everything you don't, that they need to do. But unfortunately, we are in a world in which, that hasn't been happening, and it is a real shame. I mean, Merrick Garland was a very centrist nominee. I think he's probably the most qualified nominee of the Supreme Court in our lifetimes. Chief Judge of the nation's second highest court, the D.C. Circuit, never overruled once by the Supreme Court. Just a gem of a person and a judge. And I was a fan of Gorsuch. I came out for him. So, I say this not because of anything about Justice Gorsuch, but because I think that what your question's getting at is something really important, which is, there are all sorts of gaps our founders left in the Constitution because they presumed good faith and fair dealing. And that's not what's always going on. And when you have someone or a group of folks who are so willing to break the system, then you have to worry about the system.
Neal, can I ask you, we have two overflow rooms, if not more, and they can't hear the questions, so if you could just
Great.
briefly
Thank you.
mention what
I will.
was being asked.
What do you think will happen to the 40 or so that remain at Guantanamo, especially those that are languishing, they aren't being reviewed?
Yeah. So the question is, what's going to happen to the 40 or so people at Guantanamo, and are they languishing and their cases not being reviewed? I guess the first thing to say about it, and I was recused from Gitmo, I didn't do any of it when I was in the Obama administration, so and I kind of spent 7 years doing it, so I'm kind of, was a nice period to not have to worry about it, but I do think the number has dropped from, I think it started with 800 people at Guantanamo down to a very small number of people. Professor Benjamin, I think, is in the room somewhere. He'll probably know what that number is. 60-ish, yeah. So, I think the president has said he wants to expand Guantanamo and put more people there. So, depending on what happens, I think that could be a really unfortunate thing. I mean, at the end of the Bush administration, I think we developed a strong national security consensus. Everyone from Colin Powell, even President Bush wanted to close Guantanamo, saying it was actually hurting our national security. To expand it, I think, would just be more of the kind of talk tough, actually be weak thing. But so I don't know what's going to happen. I certainly do know that if the president tries to expand it, we'll be in court about it, because I think, it's hard when you're challenging the president in a time of national security crisis to win your case. I mean, if you go back over American history, really only once in armed conflict has the president lost in a time of national security crisis before 2001. Like, I always joke, and I'll say this with reference to Roger, it's kind of like failing a class at Yale. You got to try, if you're the president, to lose before the U.S. Supreme Court, because there's such a tradition of deference. But President Bush managed to lose Gitmo 3 times because that policy was ultimately truly un-American. The idea that you could put people in a legal black hole where they had no rights. And so 3 different times the U.S. Supreme Court struck that down. And I think that'll happen again and again. So, if President Trump wants to play in that sandbox, I think it's a losing sandbox for him.
Where does the funding for the Guantanamo case come from?
The question is, where does the funding for the Guantanamo case come from? Honestly, it came from my pocket, and I was just a professor then, and so, it drove me nearly broke, quite honestly, yeah. Now, today, we do have different groups that are coming together, and ultimately, even with Gitmo, there were law firms that ultimately got involved, but those early days were costly days and tough. But ultimately, I got Perkins Coie, a law firm in Seattle, to help, and then other law firms joined that fight. And today, I think we're seeing the organized bar, the private bar. There are, I think, 40 different briefs filed in the Muslim ban case, including every major technology company, Amazon, Facebook, Google, Snap, all of them. You have just 1,000 different churches filing briefs on behalf of attacking the Muslim ban and so on. So I think we now have, the private bar has developed some institutional capacity to start to challenge the president. But I think that they also have to worry about fearing retaliation and other things. So it's a complicated thing.
Why did you pick Seattle or Washington to file the Haldeman case?
Oh, in Seattle, it was actually, it was a complicated thing, but it's very technical. But basically, we couldn't file the case on Hamdan's name initially. We had to file it from his next friend. And his next friend was Charlie Swift, the military attorney, and his residence was in Seattle. So it was a complicated thing. I didn't have any reason I wanted to be in Seattle. No offense to Seattle. It was just, it was hard to get to. I had a little kid at home, but that's where we had to file it.
One factual question, another quick question. One is, didn't Trump a couple of weeks ago talk about disbanding one of the circuit courts? And does he have the authority? Can he do that under law? And the second question is, are you concerned about the fact that now there was such a backlog of nominees for courts, and that they may all be pushed forward very quickly, and the courts will be stacked?
Yeah, so when we won that case on March 15th, the president that night, in part of what I was reading, I didn't read the whole thing to you, but is we should break up that Court of Appeals because they are, basically too liberal. The president cannot do that. Even he can't do that. Though he's definitely trying my view of what presidents are able to do. But no, it would require legislation. Now, maybe he can get that legislation through. A little bit of a problem was that the former chief judge of that circuit, one of the most prominent Republican judges in the country, Alex Kaczynski, went on 60 Minutes 2 weeks ago and said, no way. Yeah, that'd be a bad idea. And so I think it's probably hard to do that, to break up the Ninth Circuit. But it does demonstrate something that I really am concerned about. I've never seen a president who threatens a court, breaking it up, calling a judge ridiculous, having his Attorney General, Jeffrey Sessions, when we won the case, say, oh, that's just a decision by some judge on a tiny island in the Pacific. You know, when I was in the government, if we lost a case, we wouldn't call it ridiculous. We lost the case. You know, maybe we disagreed. I don't have a problem with the president saying I disagree with the ruling. Here's why. But to go further than that, or to call the first judge who ruled a so-called judge, that's what he said in a tweet, that impugns the kind of legitimacy of the judiciary and of those judges, or the state of Hawaii. And, you know, to me, that is profoundly, profoundly anti-constitutional. And I don't think that's political. It shouldn't be political. I think Republicans should agree with this as much as Democrats. So it's a really, really troubling era we're in. You know, when I lose a case and, you know, I come back at home and my kids are like, oh, you lost, that's terrible, those judges, you know, and I teach them, no, you lost, you know, but you don't label the judges, you don't go after them, you know. Once you start down that path, I don't know where that ends. As Justice Jackson said in the Barnett case, you know, we avoid those ends by avoiding the beginnings. We just don't do that. But right now we're in an era in which, you know, the president feels like he can.
Well, I must say that the one thing you can say about what Neal did today is it had nothing to do with his education at Dartmouth. It has to do with his ability. But there's one interesting thing in this last problem with Mr. Trump. I've been studying the brain and behavior for the last 20 years, and I think there's very good grounds. He has a condition called mild cognitive impairment. So that's literally what it's called. In about 20% of the cases, it's the first stage of Alzheimer's, but it has other traits. It does interfere with rational decision making. That is, I really wonder whether the 25th Amendment could be used to say he's unfit to be president, because he does have a mental condition which is not normal. It's not that he's crazy, it's another condition.
Yeah, I mean, look, I don't know anything about that, so I'm not going to comment on it. But I will leave it to say that I do think that the decisions that he's made are deeply threatening to our constitutional order, yesterday being, you know, a good example of that. And I think we should all be concerned. And I really hope that, you know, that it's not seen as political, but just seen as our system depends on certain checks and balances and certain amounts of constitutional etiquette, and we should be demanding that from our leaders. I don't care if they're Republicans or Democrats.
Just following up on that, are there any avenues short of getting the Congress to do something about it? Because it seems like he's got much of the Congress in his pocket, not necessarily literally, because his decisions and actions make a lot of sense. So are there any other ways to, or any other lines that you think can't be crossed? Because it seems like there's been a lot of line crossing and nothing happens.
So the question is, sorry I didn't repeat the one before, but the question here is, what could we do about it? Because Congress isn't much of a check to President Trump. And I guess the only thing I could say is to repeat the title of the talk, quote, "Our last best hope for constitutional order, the courts." That is to say, I think our founders left us with the courts, but not with that much else, because, you know, impeachment requires, for example, you know, the concurrence of the House and Senate separately, and with party politics if they stay the way they are, and they very well may not, because I do think the things we're talking about here, these enduring values, will be seen increasingly as not left and right, but just simply constitutional or anti-constitutional. So, you know, my hope is that we do see Congress coming through and becoming the check and balance that our founders envisioned. But short of that, I don't see, you know, I think you've got the courts and you got Congress. The president is bent, it seems to me, on eliminating dissent within the executive branch, which was what I was supposed to talk to you about today. And I think that's generally worked quite well over the last 70 years, but unfortunately, I don't see any evidence that that is going to hold in this time period. And that'll make Congress and the courts even more important, because we've had these traditions of deference from the courts to the president in the past, because there have been ordinary, regular processes. Like before I made any decision as Solicitor General, I had to get in writing the opinions of every impacted federal agency, and then I'd have a meeting, and we would debate about it. And if people disagreed, they had to share their disagreements with everyone else. There was no stovepiping, so like they couldn't just write to me. They had to write to everyone, all the agencies. And the idea was to create a debate, a vigorous debate in the executive branch before you took a significant action. Here, I feel like the president is centralizing all of it at the White House and firing those with whom he disagrees in the agencies and shortcutting that. And if that happens, I do think the courts and Congress will get more involved, because they can't trust the regular processes that have worked so well over the last 70 years anymore. Okay, yes.
Are there any signature cases about deportation that you see coming along now that there have been so many different orders regarding deportation?
Well, I do think, the question is, are there signature cases around deportation? I do think this whole question of sanctuary cities is coming to the fore. These are cities that refuse to, to deport people who are illegal or undocumented immigrants. And so the states are saying, if someone comes to the hospital, we're not going to deport them, because we want to make sure people come to the hospital. Or if someone comes and is a witness to a murder and comes to the police station to testify or to report someone, we don't want to turn that person in, because we know what's going to happen is then no one's going to come to police stations. So that's a whole big area of litigation. It's just started in San Francisco, but you're going to see it all through the country. And I think that the states and localities will win, because the Supreme Court, when it struck down part of Obamacare, said that a similar set of provisions was unconstitutional. And so I think we'll see the same thing again.
Here's a happier question for you. I think we're close to the 200th anniversary of the Dartmouth College case, and which was argued to the Supreme Court successfully by Daniel Webster. I'm just curious to know, as an undergraduate here and at Yale and 1 year at the Supreme Court, do you ever think about Daniel Webster, his arguments, his techniques?
So the truth is yes. In fact, so much so that right before coming to this lecture, I went to Baker to try and find the picture of Daniel Webster. And I don't know if I'm just getting old, but I couldn't find it. Actually, in the Lawyers' Lounge of the Supreme Court is one statue, and it's of Daniel Webster. And I look at it every time before I argue. I'm no Daniel Webster, but I do share the same college, so I'll take it.
Among the briefs in the ongoing litigation, and you may not want to comment for that reason, is one book that was put together by a huge number of national security people from the last administration, and there would have been a lot of Republicans who signed on as well, but they sort of wanted to preserve their ability to try to moderate the administration, so they decided late in the game not to. The argument of the brief is that the ban is not in our national security interest, and quite to the contrary, it will damage our national security quite significantly. If it hadn't been for Trump's many invocations of the need for a Muslim ban or something like that, do you believe the courts should entertain that kind of argument? I mean, we're both, I think, strong executive branch guys, and so it seems to me that it's highly problematic, and at the same time, I find the policy, envisioned policy appalling.
Yeah, so the question is that there was a brief filed on behalf of former national security officials saying that the Muslim ban actually reduces our nation's security. And the question, tell me if I'm getting this right, is should federal courts entertain and adjudicate and referee claims when the president says, I need something for national security, and other folks disagree, should the federal courts be involved in refereeing that dispute? So first of all, the brief is actually, it's not just former, Obama administration people. I mean, it's got people like General Hayden, who served in, the Bush administration in the intel community as well. So I think it's a broader range brief, which makes, I think, some pretty fundamental points. Like, if you want our national security to be improved, angering the Islamic world and saying, we don't trust you, you're all potential terrorists, is probably not a good way to begin. There's also a brief, by the way, by 17 different states, including red states like Iowa and North Carolina that voted for Trump in the last election, that also says that we, state and local officials, officers, are often the first the first eyes on the ground when it comes to terrorism, and they believe that the Muslim ban, by poisoning relations in their communities, actually makes us less safe for similar reasons. People aren't coming forward and stuff like that. In general, I'm someone who believes that federal courts should defer to executive branch views on national security, so long as they make some sense. These ones don't make any sense. And that's why, as Sally Yates just testified 2 days ago in Congress, President Trump didn't ask any of the experts at the Justice Department whether or not you needed this Muslim ban. He just did it. She found out about it by watching it on TV. She was the Attorney General at the time. She's the acting Attorney General. She didn't know about it. So it's definitely, I do have this view that when you follow regular processes in the national security establishment and you're the executive, absolutely you should get deference to the decisions that you make. But this is anything but that. And so, and that's why they've tried so many different ways to keep these cases out of the federal courts, despite President Trump's tweets saying, see you in court. They don't want these cases in court. No, I mean, they have 10 different doctrines that try and say this case doesn't belong in court for this reason or that reason. So much so that the Trump administration did something I've never seen, even at the height of the Bush administration when Vice President Cheney was taking a very active role in the litigation on Guantanamo and drone strikes and other things. They never said what Trump said in this brief, which was just the mere act of the federal courts reviewing the case, regardless of which way they rule, undermined our national security. And that's an astounding proposition, and it's a ridiculous one. It's totally anti-constitutional. Last question, I think, is that? Okay, okay, great.
If I read the publicity at the time correctly, the architect, the author of the first ban was Stephen Miller. And so I thought, what a sloppy piece of work for a lawyer. Where did he go to law school? And discovered that he didn't.
Yeah, so the question is, the first ban reports are that it was written by Stephen Miller. What a sloppy piece of work. Where did he go to law school? And then the point is he didn't go to law school. I don't know who wrote the thing, but it is sloppy. And I'm the last person to say that we want to hamstring the president when it comes to protecting our national security. I think there are real threats out there, and increasingly so. But I don't think going back to Professor Benjamin's point, I don't think any real responsible national security professional who works in this field thinks this is the way to do it, which is why the Department of Homeland Security had a draft report that the Trump administration suppressed, which said this is absolutely the wrong way to go about it. And nationality-based discrimination like this will make us less safe, not more. And that's why, just to connect the dots for everyone, why I tell the Hirabayashi story, because I am concerned about what information is being publicly put out and what is actually the true experts in these agencies and what do they think. The federal courts hopefully will start to uncover some of that. So thank you very much.